This Honorable Court of Appeals is in session.
Good morning, lawyers. Before we call the case, just a brief reminder that if we don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and pause, and our tech experts will get us back going again. Call the case, please.
Laura Cowan Coffey versus David L. Coffey.
We'll hear from the appellant.
Thank you. May it please the court. I am Melissa Carrasco with the law firm of Edgerton McAfee in Knoxville, Tennessee, representing the appellant, Mr. David L. Coffey. I would like to reserve 3 minutes for rebuttal.
Yeah.
This appeal seeks this court's construction of a very narrow but very important and very practical issue: how post-judgment interest should be calculated. This court's construction is necessary because the post-judgment interest statute is ambiguous. As the Tennessee Supreme Court has stated time and time again, the basic rule of statutory construction is to ascertain and give effect to the intention and purpose of the legislature. In doing so, courts are to ascertain a statute's purpose from its plain and ordinary meaning of its language without a forced or subtle construction. However, a statute is ambiguous if it is capable of conveying more than one meaning. And when a statute is ambiguous, then the court may look elsewhere to determine legislative intent. Here, the post-judgment interest statute contains an ambiguity regarding the interest rates that should be applied when calculating post-judgment interest. Tennessee's framework for post-judgment interest is found in a collection of statutes codified in Title 47, Chapter 14, Part 1 of the Tennessee Code. This statutory scheme is not ambiguous on two issues. First, it is not ambiguous as to the day that post-judgment interest begins to accrue. Section 47-14-122 states that interest shall be computed on every judgment from the day that the jury or the court sitting without a jury renders a verdict. Second, it is not ambiguous as to what interest actually is. Section 47-14-102-8 defines interest as compensation for the use or detention of or forbearance of to collect money over a period of time. However, the statute is ambiguous as to whether the post-judgment interest rate is a flat rate that is set on the date of judgment or a rate that fluctuates every 6 months. Section 47-14-121 introduces two time periods. For judgments entered between July and December, the post-judgment interest rate is 2% less than the formula rate published by the Commissioner of Financial Institutions for June of the same year. For judgments entered between January and June, the post-judgment interest rate is 2% less than the formula rate published by the Commissioner of Financial Institutions for December of the prior year. So as an initial matter, it should be fairly easy to determine the rate of post-judgment interest that applies at the time the judgment is entered. Depending on when the judgment is entered, you look at the formula rate for either June or the preceding December and subtract 2%. In fact, that is what the statute says in 47-14-121 subsection B. To assist the parties in the courts in determining and applying the interest rate on judgment for the 6-month period in which a judgment is entered, the administrative office of the courts is to publish the applicable interest rate. By using this language for the 6-month period in which the judgment is entered, the statute only identifies which post-judgment interest rate applies to that initial 6-month period. The statute is ambiguous as to what interest rates should apply to the period after that initial 6-month period. In fact, the statute does not unambiguously say what interest rate applies for any period other than the 6-month period in which the judgment is entered. However, the statute gives us 3 clues as to the post-judgment interest rates. First, the statute says that the post-judgment interest rate is relative to the formula rate. Section 47-14-102, Section 7 defines formula rate as an annual rate of interest that fluctuates on a weekly basis based on the prime rate published by the Federal Reserve. So we can deduce that the post-judgment interest rate is intended to fluctuate as well. Second, subsection B1 goes on to say that the administrative office of the courts shall publish the interest rates on judgments that apply for the new 6-month period. By pegging the post-judgment interest rate to the formula rate, which by definition fluctuates, And by introducing the phrase "for the new 6-month period," the statute indicates that the post-judgment interest rate should fluctuate based on the published formula rate every 6 months between the time the judgment is entered and the time the judgment is paid. Third, subsection C clearly distinguishes a scenario where a judgment is based on a statute or other written instrument that fixes a rate of interest. In that situation, the judgment shall bear the interest at the rate so fixed. It is that simple. If a statute or some written instrument provides a fixed rate of interest, then that is the post-judgment interest rate. If not, then the post-judgment interest rate is based by the formula rate. It is telling that the General Assembly felt the need to distinguish between statutes that have a fixed rate of interest and the formula rate described earlier in the statute. This indicates that the General Assembly intended for post-judgment interest to be something other than a fixed rate of interest. In addition to the language of the statute, there are 2 reasons why the General Assembly most likely intended for the post-judgment interest rate to fluctuate rather than being a flat interest rate set at the time of judgment. First, in 2012, the General Assembly completely overhauled the statute to replace a flat interest rate with one that fluctuates every 6 months. Prior to 2012, the statute provided for a flat post-judgment interest rate of 10% per annum. Had the General Assembly intended for the post-judgment interest rate to be a flat rate set at the time of judgment, it would not have needed to revise the statute. Also, it is worth noting that the prior version of the statute distinguished between post-judgment interest for judgments based on notes, contracts, or other writings with a fixed rate of interest. In other words, if a judgment was based on a note that identified a fixed rate of interest, post-judgment interest was calculated at that fixed rate, and for all other judgments, post-judgment interest was calculated at a fixed rate of 10%. However, when the statute was revised in 2012, the General Assembly also revised that list in subsection C to add the word statute. Now, subsection C distinguishes between judgments based on a statute or a note or other writing that has a fixed rate of interest and any other kind of judgment. The intent of the General Assembly was to distinguish between judgments based on a statute in which a fixed rate of interest would apply and judgments for which the fluctuating formula rate would apply. The second reason why the General Assembly most likely intended to adopt a fluctuating post-judgment interest rate is a more practical one and speaks to the purpose of post-judgment interest. The purpose of post-judgment interest is not to punish the losing party. Its purpose is merely to compensate a successful party for being deprived of the compensation for its loss between the time of the entry of judgment and the time of payment. Interest rates fluctuate with the market. That is why the formula rate is revised every week. And that is why Appellee's construction of the statute fails. If the General Assembly intended for the statute to require a flat interest rate set on the date of judgment, then that would be contrary to the policy reasons for post-judgment interest. A successful plaintiff would get a windfall if she happened to get a judgment on a date when the market interest rates were high, only to find that the rates dropped a few months later. Similarly, a defendant would get a windfall if a judgment was rendered on a date in which the interest rates were low, but then rose 3 months later. In either scenario, such a windfall is contrary to the purpose of post-judgment interest. The only way to avoid a windfall for one party or the other and to actually compensate the plaintiff for the interest she could have earned had the judgment been paid on the date of the judgment rather than being appealed or some other scenario is to have the post-judgment interest rate fluctuate with the market. That appears to be what the General Assembly intended when it overhauled the statute in 2012. And for this reason—
Counsel, I'm sorry, let me interrupt you a second. Would you agree that what your argument is that 121A is ambiguous because of 121B?
Yes, I think that is correct, because 121B is where the language about the 6-month period in which the judgment is entered, as well as the new 6-month period, is introduced.
All right, so if we had this 121A, that wouldn't be ambiguous.
I think it would not be ambiguous as to the date and the interest rate as of the date that the judgment was entered, but it still leaves open the question as to what interest rate should apply should the judgment not be paid literally on the date that the judgment is entered.
How do you get that from subsection A, from subsection 1 and 2 of
Certainly. So subsection A, 1 and 2 simply states what the interest rate of judgment will be depending on the date that the judgment is entered. It does not say what interest rate, considering the fact that the interest rate fluctuates and changes every 6 months. It doesn't say whether that interest rate continues on as of the date that the judgment is entered and just continues on indefinitely until it is paid, or if that interest rate also fluctuates as the interest rate is updated every 6 months.
What about no section 122? Because that says interest shall be computed on every judgment from the day on which the jury or the court returned the verdict. Is the question not answered by that language, which just says, hey, we're calculating interest from this date?
I do not think that actually answers the question, because it only sets the day that the interest starts to accrue. It would make sense, and under the old statutory scheme, it actually made a whole lot of sense, because the old statutory scheme set a single interest rate of 10%. Up until 2012, everyone knew that the day that that interest started to accrue was the day that the judgment was entered. And then that interest rate, according to the statute, never changed. It was 10% until it was paid. However, when the statute was updated in 2012, that all changed with this fluctuation, with these recomputations that happen every 6 months. And again, by pegging that interest rate to the formula rate, the statute actually is intended to fluctuate and is intended to change over time. The question is, should that interest rate for post-judgment interest, it's easy to calculate on the date of the judgment, but should it also be updated over the periods of time, say that the case is on appeal and other things like that, until the judgment is paid?
Do you agree, counsel, that in your position that the statute is ambiguous, that there are two potential interpretations of it?
Yes, I think that is accurate. That is certainly what the courts have determined to be what an ambiguity is in a statute.
Yeah. Okay.
I will go ahead and address, I think I have 10 seconds, but Appellee raises two arguments. First, having to do with the statement on the Administrative Office of the Courts. I will just note that the statute only directs the AOC to publish and to recalculate that interest rate, not to construe it. Thank you. I'll reserve the rest for rebuttal.
Yeah, you have your time for that. We'll hear from the appellee.
May it please the court. My name is Chris Kane, and I represent the plaintiff appellee, Lauren Cowan Coffey. Respectfully, the trial court correctly determined the post-judgment interest rate to be 6.75%. And respectfully, this appeal is frivolous. I would like to start by talking about the post-judgment interest rate. In light of the plain language of the statute, which is unambiguous, the AOC's publication and pronouncement, common sense, and the court's decision, this court's decision in Cardle versus Cardle, there's no question that the trial court correctly determined that the interest rate was 6.75% and that it did not fluctuate. Post-judgment interest is a statutory right, and it accrues from the day of the judgment. And this is from Tennessee Code 4714-122. And as Judge Davis pointed out, 4714-122 provides that the interest rate, not a interest rate, but the interest rate, singular, shall be computed from the day on which the jury returns its verdict, or the court in this case returns its verdict. So it's a matter of simple computation. There are two constants throughout this, and they're contained in the statute. One is the date of the judgment. That never changes. The second constant is the interest rate is determined as of December of the previous year for judgments entered between January and June. That never changes. That interest rate never changes. It's computed at that time and is always the rate for that judgment entered during that period of time. Additionally, 121A2 provides that for any judgment entered between January 1 and January 30th, the, again, interest rate on judgments per annum in all courts shall be equal to 2% less than the formula rate. Again, that's a constant. That formula is a constant, and it's determined in the basically the 6 months preceding the judgment. So the statute does not say anything about post-judgment interest rate is the first or initial rate. It does not say that the interest rate will fluctuate. Rather, it states that the interest rate shall be this. 4714-121 then directs the AOC to calculate and publish post-judgment interest rates. The AOC did so, and as of the judgment that was entered in this case, the post-judgment interest rate was 6.75%. And further, the AOC unequivocally states on its website that the rate does not fluctuate and remains in effect when the judgment is entered. And obviously that makes complete sense in the sense that once this judgment has been entered, the plaintiff is entitled to that money at that point. And it is the market conditions then existing at that point. That's the purpose of recalculating it later on subsequently, is because the market may change and it may be necessary that there be a different post-judgment interest rate for judgments entered at that time because the market has changed. But as of the entry of this judgment in January of 2020, the market at that time was reflective of a 6.75% interest rate. And Ms. Coffey at that time was entitled to that money that she obtained in the judgment and was entitled to invest that in the market as she saw fit. And the market at the time, as the legislature has deemed, was reflective of a 6.75% interest rate. Turning to this court's decision in Cardle versus Cardle, and this is instructive. There's no mention of that in her argument, in Ms. Carrasco's argument. In that case, the Court of Appeals was faced with the issue of post-judgment interest. The trial court awarded the wife the standard 10% of interest, 10% interest on the judgment. The Court of Appeals, in an opinion dated May 17, 2017, recited to 4714-121 and remanded the case to the trial court to lower the interest rate on the judgment to 5.5%. And it said the interest rate applicable to judgments entered between January 1 and January 30, 2016. The interesting thing about that case is that while this case was on appeal, the interest rate decreased during that 6 month period of time. And when the Court of Appeals remanded it back to the trial court, it made no mention of computing it based on 5.75% and then the lower rate of 5.25%. It just sent it back to the trial court to compute the interest rate based on the interest rate applicable at the time the judgment was entered. That's exactly the situation we have here. And turning to another point to make is that if the interest rate in this situation had gone up for the period of time after the judgment was entered, I'm confident that the appellant would not be here arguing that Ms. Coffey was entitled to more money in post-judgment interest.
I expect we'd be pretty confident that both sides' positions would be exactly reversed.
But there's no question that.
Let me ask you a question though. What in B1 says shall calculate the interest rate on judgments that applies for the new 6 months period pursuant to subsection A. What does it mean, the new 6 months period?
Well, respectfully, Your Honor, I believe what that means is that the legislature has recognized that market conditions do change, and it's important for the interest rate to, at the time the judgment is entered into, to reflect what the market conditions are at the time the judgment is entered. And they have chosen, I think arbitrarily, maybe not arbitrarily, but they've chosen a 6 month interval to recompute interest rates for judgments entered during that period of time to reflect market conditions at the time the judgment is entered. And that's the point of that. I hope I've answered your question there. With all due respect, this appeal is frivolous in light of the language of the statute, pronouncements of the AOC, Cardell versus Cardell, and common sense. And the idea that Ms. Coffey has received or would receive a windfall it is ridiculous on its face, given the fact that she was entitled to that money the day the judgment was entered. And again, she's entitled to that money. She could invest it. She could play the market, do whatever she needs to do to protect that money, let it grow. And it's not for the defendant to decide when they pay that judgment. At the time that judgment is entered, the two constants are the date of the judgment and the formula rate. Those things never change. And you go back to the statute, which says that interest shall be computed from the day on which the jury returns the verdict. And in this case, it was the court that returned the verdict. But it's computed as of that date. There is no ambiguity here. There's no idea in here that the rate's going to fluctuate on a judgment that's been entered. It doesn't change. And respectfully, trial court's decision should be affirmed. I don't have anything else to say unless you folks have any questions for me.
I hear none. Thank you. We're here from the appellate rebuttal.
Thank you. Counsel mentioned two things, which I think were very important acknowledgments of our position. And the first thing that counsel mentioned was that had Ms. Coffey been paid this judgment on the date that the judgment was entered, she could have invested it in the market. She could have earned interest on it. And that is precisely the purpose of post-judgment interest. And that is precisely the reason why the General Assembly, in our opinion, in our reading of the statute, intended for that post-judgment interest to fluctuate. Had Ms. Coffey invested that money in the market, it would have been subject to market conditions, which, as everyone knows, fluctuates. And in fact, that is why the statute pegs that post-judgment interest rate to the formula rate, because the formula rate in and of itself fluctuates based on the rates that are published by the Federal Reserve. So the idea of post-judgment interest, I would agree with counsel, is exactly right, in the sense that had she had that money, she could have invested it and it could have gone up, it could have gone down, the money would have been subject to market interest rates, and that is precisely the point of post-judgment interest. The second thing,
Counsel, what do you say about Cardell versus Cardell?
I was going to address Cardell. So Cardell in and of itself does not actually address what counsel says it addresses. Cardell versus Cardell, in that court, the trial court awarded a flat per annum 10% in post-judgment interest rate based on the prior version of the statute. The Court of Appeals took a look at it and said, no, the statute changed in 2012. You need to apply the formula rate. And in that situation, the Court of Appeals applied the rate as of the date of the judgment. The Court of Appeals did not address, and it appears it just simply was not raised with the Court of Appeals as to whether that rate should change for or should be different for any particular periods of time. It simply was not addressed in Cardell. Cardell did, however, recognize the fluctuating formula rate as set forth in the statute. So unfortunately, I don't think Cardell actually answers the question as to whether post-judgment interest should be changed based on different periods of time, as that rate is updated and is set forth on the Administrative Office of the Court website. The last thing I think I should address is this idea that calculating post-judgment interest might be too cumbersome for the courts or for appellants. Again, litigants and the courts are perfectly capable of looking at the interest rate as of the date that the judgment is entered, and it certainly is not that cumbersome to recalculate post-judgment interest for the periods of time between the entry of the judgment and the payment of the judgment. We have provided that calculation in our brief so that you can see just how simple it is, and unless the court really wants me to, I will not walk you through that calculation. That is all I had. Thank you so much.
Court's thanks to counsel for both sides. We appreciate your briefs and your oral argument on this. Madam Clerk, will you please recess court till our next scheduled case?
This honorable court is in recess until 11:30 a.m.
Thank you.
Thank you, lawyer.